INL's Advocate. INL's Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Suresh C. Jambhale. He is BCom and LLB. He graduated his law from Rajashri Shahu Law College, Vikhroli in the year 2021. He is currently pursuing LLM from the Mumbai University in criminal law. He is also pursuing his postgraduate diploma in forensic science in MNLU. His areas of practice are criminal law, civil laws, arbitration and commercial laws. His domain of practice is in the appellate side and the original side in the region of Bombay. Today, he is going to speak on role of litigant in litigation. So without wasting further time, I would request Advocate Suresh to commence with his lecture. Thank you.
Thank you so much for giving me one of the opportunity to express my view. Today I am going to deal with one of the important topic, which is what is the role of litigants in litigation. So I will give vote of thanks to all the audience and the Hammurabi Tablets for providing me such a beautiful platform to express the opinion and view of my views before delivering lecture. So before we go ahead, I will tell you why this topic was chosen for delivering lecture before this good platform. So whenever we see many of the litigants are facing many difficulties before the various forums, before the various judicial bodies, and the many litigants ask the advocate what should be our role and in what extent we should be deal with the manner, and if something which acts, if I did wrong before the court, in what quantum and in what extent it is going to prejudice myself. So because of that, this topic has been covered to help you, to guide you in the manner that it will help not during only when the offense has been committed, but during the pre-trial stage, during the investigation stage when the offense has been committed, and thereafter during the period where trials has been begun but till not has been concluded. So before that, so there are various stages which can be going to cover it throughout my lecture. So why the fact has been essential, because see, we have seen on many of the cases the litigants are very prominent person who are the essential for the completion of whole prosecution in either of civil, in either of criminal matters. Why? Because the person who has suffered, the burden upon whom to prove the case, that is an essential onus upon not only on the plaintiff as well as on the prosecution. So we have seen in criminal as well as civil cases that the onus will be upon the plaintiff, will be upon the prosecution to assert what they are seeking relief thereunder. So what is my suggestions and the views that we should understand what the extent of role, how we can assist the court during the whole phase of the trial. So before we proceed ahead, I will little bit touch on more part of the criminal part, where from the beginning of the stage when the FIR lodged till the conclusion of trial, how we can deal with the minor, how we can assist the prosecution, how we can assist the court, how we can assist the investigation authorities and other witnesses who are aligning with the prosecution case. So before we proceed ahead, we should understand what is the meaning of terminology of complainant, victim, as well as the person we say the informant. People, we have seen on multiple cases there is a slight difference in between that, because we have seen people are more confused that whether complainant itself victim, complainant is victim, complainant itself the informant or what. So we should understand there is a difference between that, which deliberately clears out what is the meaning of informant and complaint. So for that purpose, I will take some of the example which will help you to understand what is the meaning of informant, what is the difference between the complainant and informant, and what is the difference between the victim and the complainant. So we will take the example which will help you to understand what does the meaning of the informant. So for that, the Supreme Court as well as thereafter various chain of the rulings which has clarified what is the meaning of informant. So for that purpose I will tell you the one example. Informant means the person who informed the concerned police station about the alleged offence. So before we go ahead, we should understand who can inform about the alleged incident to the concerned police station, and why is it necessary that the incident has to be reported. So any person who was roaming on the road, if so he saw something that something has been happened on road and which is an offence, and it has, for that purpose punishment has to be implicated upon the accused or person who has committed. So therefore in simple language I can say anybody can be a witness, anybody can be the informant who has observed, who has seen, who has heard something illegal things had been often. So these terms very clarify that what is the meaning of informant. So informant can be anybody. So in landmark judgment M. Suvarna versus State of Karnataka, the Supreme Court as well as the Karnataka High Court has explained the what is the meaning of informant. So now can the informant and victim can be the same? The answer is yes, but it has to be same. The answer is no. Sometimes the victim can be different, informant can be different. In some example I will tell, in POXO cases we have seen the victim is a minor girl or minor child who has not completed 18 years. So in that cases the guardian sometimes lodge the FIR before the court or the person who has seen. So now we have clarified that who is the informant and who is the informant and who is the complainant in itself. So we understand that a complainant, we check that in negotiable instrument act we will cover the who is the meaning complainant. So in some of the cases we have seen the complainant who is that who is alleging the offence. So we have distinguished that who is the meaning complainant, informant and the victim. So sometimes the victim may allege the offence, so court has accepted. So it does not mean that all the three terminologies should be the same. So before we go ahead, we understand, so what is the meaning of recording the substance of allegation and it should be in what form. So we have dealt with the various areas. People has noticed that something has been happened against me and you. So therefore people are used to complain about what wrong happens to them. So I am not going in much detail with regards to what is a cognizable offence and non-cognizable offence. Anything which happens to, which is in illegal form, for that the punishment has to be incurred in criminal manner. For that purpose we can reach to the concerned police station and we can given the what has been alleged against us. So in that category, if the offencer falls under the category of cognizable offence, then police has to record the FIR. So that what the meaning of FIR first we should understand. So meaning of the FIR is not the substance of allegation, it should be in the form and it has to be reached to the concerned police station. There and upon the information from the concerned complainant or informant, police will reduce into writing. So as a being litigant, what is the important role here and after? Anything has happened to you, you should be reached to the concerned police station and you have to inform the concerned police station or the senior inspector of that police station by in oral form or it should be in written form. It does not necessary that you should always write the FIR in written format. You can give the orally deposition before the concerned police station also. So what is the mandatory? First, if anything is happened, we have to reach to concerned police station and we have to give the in written format or in oral format. It does not mandatory that you should be give the allegation or complaint in written or oral. So it is depend on person to person, but it's better if you given in written, then it will helpful for the further proceeding ahead. So we have discussed now what are the ways to lodge the complaint. So because this is a very essential factor which determines that we can lodge the complaint in different format. So now we are coming to the new issue which I have seen what should be narrated in the FIR. So why this factor we have covered, because in many of the cases even I have seen and even the court has observed that. So why the FIR is a very essential factor, why the complaint is a very essential factor, because as we have seen in many of the cases, court has said the complainant he stands on the driver's seat. Why? Because the whole case starts from him and it has to conclude whether it should be in acquittal or it may be in the form of conviction, but the witnesses and the complainant stands on the driver's seat. So what is the relation between the complainant and the court, complainant and the prosecutor, complainant itself on driver's seat, and the court and the prosecution I will call as a conductor for the particular direction, because he guides, he founds a roadmap to reach the conclusion of trial, which helps the court to determine whether the person who is standing in the accused box, whether he has committed the offense or not. So what we have to narrate in the FIR, because many of the people is always confused, because we have seen the FIR is not only lodged by the people who are from the good educated background, but we have seen the many of the person who are from the tribal areas, who are from the uneducated areas, they feel very scary by stating that, sir, what should I do now, because I am not a person who are always facilitated with the law background, so how I can lodge the FIR to the concerned police station. People, sometimes the concerned police station officers and personnel so rude, they say, what happens to you, why you are saying lie, what you are delaying, what delays quantum. So in that case, how should be our approach to be? So this is a very essential fact which we need to be addressed out, that how we can narrate the FIR, because FIR is not a substantial piece of evidence, but this is a primary piece of evidence which we can't ignore it, because this is a foundation of case. From there and upon we can build our case through the form of investigation, and that can be reached at the trial stage. But if your FIR is going to be in a wrong way, then whole investigation and whole case may be go in the other direction, which was but not necessary, and the result of that, the accused may be the acquitted. So the narration of FIR will be the essential factor, and here being a litigant and being the person who was the primary has been played the role. So I believe that the narration of FIR will be important. So what we have to be narrated in the FIR? First, we have to describe the offense in detailed format, to that what happens to you, what was your position in that, not only in that extent, but how many accused were indulged in that particular offense, what was the clothes they were wearing that particular time, what kind of weapons they have used, we have to describe the weapons, then quantum of injury inflicted, the nature of offenses, and the many other things. So we as a being witness, because see, as we have discussed earlier, who can lodge the FIR? First, any witness can be lodged the FIR. The person who was roaming on the road, he saw something that something was kidnapping was going on from the other end, he can lodge the FIR. Even in many of the cases we have seen, even concerned police station or official personnel of the police station may have also lodged the FIR. So being a witness also, we can lodge the FIR on the basis of what we have seen, what we have heard, what we have smelled, and each and every description of the accused. But now, as a being a layman man, it's very quite difficult. What we have seen that as a being layman man, always carry format before the concerned police station. We have seen that the police stations are not much familiar with the other layman man. So in that cases, we have noted that in many of the cases of the instance, people did not deliver or did not narrate the proper FIR or complaint to the concerned police officer, and because of that we have seen that the many of the cases are diverted to the wrong way. So what precautions we need to be taken into mind? First, as we have seen, as a being the litigant or the person as a being complainant, what precautions we require to be taken care while registering any FIR or complaint to the concerned police station. So the first primary duty upon us to not only to lodge the FIR, but timely reporting of the FIR or complaint. As a Supreme Court, in many of the cases we have seen that the time of reporting date will be the essential and crucial factor to determine, to check the reliability and other circumstantial form also. So it's essential to understand that the timely reporting of any cognizable offense or even non-cognizable offense is very crucial, play a role in during the trial. Why it will be said, so we will discuss in other way also. When we are narrating the offense, so we need to allege that what actually offense has been committed by the person and the form of injury because of offense, the weapons used by the offense, not in the form, the conduct of the accused, any identification marks for the better identification, the witnesses who are standing or surrounding to the circumstances, and all they play the important role. So these factors we need to be taken into our mind before we narrate everything. So why it will be the essential to lodge the FIR as earlier best? Because in Supreme Court and thereafter in many of the high courts of the particular states, they have said that non-reporting of or delay in lodging of FIR or complaint court can believes that this is in a whole version of complaint can be unreliable. So answer is no. In many of the cases we have seen that the delay in reporting of complaint or FIR, it may be because of the various socio-economic factors. Sometimes we have seen that the uneducated people or people from the low background may face difficulty to come up out of the clutches of the social background effects. Because of that, there may be the delay on the part of for lodging the FIR. We have seen in many of cases like in POXO offences, in preventive corruption offences, it may be in white collar offences also, or it can be in the case of assault or in different kind of offences. Because of political pressure, there may be delay on FIR. Because sometimes it's happened that people are not aware about the right, that may be the reason for delay in the lodging of FIR. Sometimes the ignorance of law, that is also factor which may amount for the delay in FIR. So delay in FIR or delay in lodging a complaint can be the detrimental for the prosecution. To answer is yes, but at what extent it should be. So as a being the informant, it is primary duty upon us to lodge the complaint as early as possible. So we have seen what is the meaning of delay and what is the meaning of inordinate delay. So in many of cases, Supreme Court has said that the inordinate delay is one of the factor which we can keep in our mind for the purpose of trial and the purpose of adjudication of issues which was the part and of substantial allegation. So whenever as a being an informant, when you go to the concerned police station for lodging any complaint or FIR, we have to explain the delay, why delay has been occurred, not in the form of FIR only, but during the statements when the IO has called us. So delay may be in the various forms. So we have to explain the delay, that is the primary duty upon us. So as we have discussed, why it is an essential factor to delay has to be explained, because in Supreme Court, in various cases like Jitendra Kumar versus State of Haryana, in that court observed that delay may be occurred because of the threat from the accused. Yes. In many of the POXO cases we have seen, in many of the murder cases we have seen that political rivalry because of the dominant factors who pressures the complainant to come forward for lodging the complaint. But in that cases court observes that only the delay factors cannot vitiate the whole proceeding because delay has occurred. If delay has been satisfied by the prosecution, the delay will not vitiate the whole proceeding. That is an essential factor as we have to keep in mind as a being litigant. So what will be the evidentiary value for the purpose of FIR when delay has been occurred? So evidentiary value, if as a being litigant, we need to keep in mind that as a purpose of evidence, the FIR is having the particular evidentiary value in eyes of court. There and after, when delay occurs, we need to understand one fact, that delay is going to challenge by the defense, not in the civil as well as criminal as well. For that, defense is going to take the much of questions upon you by stating that why delay has been occurred. Delay has been not explained by in FIR or through form of the statements also. And when the such kind of delay is not explained, so that going to cost you not in the form of acquittal, but it may take the different inferences in the mind of court which we need to be considered. Now we have seen that whenever any complaint is lodged, people have the various questions in their mind, whether omission, they fail to narrate particular incident in particular allegations in the form of FIR, it will going to cost them? So of course answer is yes. So when minor infirmities are there, court has observed in S. Kaur versus Baldev Singh and others in 1992, this is the apex court judgment which says if minor infirmities are there in FIR, it does not going to make the whole FIR unreliable. So of course it's create the question upon the reliability, but it does not create a whole FIR unreliable. Prosecution can rely, court can rely upon the other documents, other evidentiary values and circumstantial evidence which was part and substantial for the proving the case. Court may rely upon that, but the whole small and minor infirmity does not amount to go to change of prosecution state. So I want to add certain points which shows that what is the meaning omission, contradictions and the development in the case. So we have seen the omission is certain things which we have forget to mention in our FIR. That is a very crucial factor. But as we have seen in many of the cases, like when the people lodge the complaint, the state of mind of such kind of complainants may not be stable. We have seen in many of the cases the police lodge the FIR on the basis when the people are standing in the sometime before the hospitals, may not be in such condition who can deliver the narrate the complaint in proper format. So in that circumstances, court may permit if any omissions occurs. But deliberate omission and thereafter after a certain date, if the complaint is coming before the police station and giving further details about the allegation, that is going to hamper the whole case. So we need to keep in mind, so whatever happens, we have to describe in proper format before the concerned IO, and we need to check also, it is our duty upon the as a being litigant in that particular format, what he has narrated whether it is true and correct or not. If nothing is true and correct, then we have to inform, sir, this is not correct, we need to alter or we need to do certain modification in that extent. That is the primary duty upon the informant. Second, contradictions. As we have seen in FIR also, some statement may be contradictory to upper version what you have narrated. So we have to be very careful when we are alleging any offense in the form of complaint or maybe in the form of FIR, what we have alleged in the FIR or complaint. If any contradictions appear itself, so it's going to hamper your whole case. So your version of complaint should not be hampered itself in that. Third point which I am going to cover, the development. As we have seen, the many of the complainants are using the law for the twisting the hands of the other side. So as being a complainant, we should not make as much as development and prosecution story. We have to narrate whatever it's happened to you in shorter format, which can be in concise manner for further development. Now very crucial topic which I am going to cover now. During the lodging of FIR, we have seen that the many of the offences which police has recorded but non-mentioning of the names in the FIR. We have seen that the many times defense counsel stayed before the court during the bail or in many of the case like in trials. They asked various questions upon that. Non-mentioning of the name of the accused in the prosecution like in FIR. So at what extent it is going to hamper you? I want to say in that part, sometimes we know the person who is committing the offense. In that cases, it is duty upon us to narrate the name of that particular person. But what's happened when we are the unknown person who are going to commit the offense upon us? So the first factor we need to be considered at that time, whenever the unknown person are committing offense upon any particular person, first that person we have to quantify that how many person was indulged in that particular offense. Then we have to give any identification marks, like any marks upon the body, any specific identification which can discover who was the person who was indulged in the offense and how many persons. So as a being informant for that particular case, we have observed that this 9 person was indulged in the for commission of offense. We have to now quote the number in an FIR that the 9 person was indulged. Even though we can say that the unknown person it was there, that is not going to hamper it, but we have to describe the persons who was indulged in the offense. So I want to tell one important thing. Benefit can be given to the accused when the name of that particular accused was not mentioned? Defense is going to take the advantage for that. Of course, there is no harm in that. So in Shamlal Ghosh versus State of Bengal, it's mentioned that the non-mentioning of the witness in FIR is not going to hamper. and mentioning of witnesses in FIR necessary when such witnesses are present on the scene of occurrence. So why this is very essential, we have seen in many of the cases have been informant describe any offences in when such a offence has been committed in the group of people. So as a being informant, when I know the 4 person was standing or they were standing beside of me and I know them, so we have to mention that the factors in our FIR by stating the person, the Mr. X, Y, Z was standing there and they are the eyewitness for that. So if non-mentioning of such kind of person who was standing just beside of me will be the one of the crucial factor which can determine the whole case at the later stage. If the non-mentioning of such persons happen, then what is going to happen? Of course, as a being informant, what we have to brought before the concerned police station and the court, that the whole incident has happened in proper format. If non-mentioning of such persons are there, then what is going to happen? It is going to cast the doubt upon your story, and court can make the adverse inference about your story, and that maybe create reasonable doubt in the mind of court, and because of that the advantage may be given to the accused and it can be result in the acquittal. Because definitely in the criminal format, when the alleged incident has to prove, but we does not required to prove the facts, but we have to prove the case beyond the reasonable doubt. Because in penal form, whenever any allegations are narrated, we need to prove the facts and we have to clarify all reasonable doubts in the minds of court, which will be the necessary. Because if small doubts also there in the minds of court which can leads to the penalizing of wrong person, the court in that cases we have seen no single person should be punished for what non-doing of particular act. So this is a landmark judgment. It says even though 10 person are standing in the queue and out of that 10% the 9 has committed offense, but courts are confused who is the one whole person who has not committed the offense. In that case also court may acquit all the 10%. This is an observation of court. So in Ranbir versus State of UP in 2009, it's held that all the name of witnesses has to be mentioned in FIR when the witnesses are standing on the spot of or on the scene of occurrence. So this is something judgment which says what is the credibility and what is the relevancy of FIR when we have to narrate. So all these factors we need to be considered as a being person who is narrating. So as we have discussed earlier, what is the meaning of informant, what is the meaning of complainant and the victim. So as we have discussed now how we need to lodge the FIR. So there and after, what is the role of litigation, what is the role of litigant for the purpose of in pre-trial stage and there and after. So whenever you lodge the FIR, so as a being person who was on a driver's seat, you have to assist the investigation authorities. Then how you can going to assist the investigation order, that is a crucial factor. So whenever any offence has been committed, we have to assist the IO for drawing the site of scene of occurrence. We have to assist the prosecution, means the investigation authorities, for collecting the various evidences. We have to narrate the whole incident as we have seen, we have heard, we have touched, we have smelled. So all these factors we need to inform to the investigation authorities. That will be the very crucial factor. Second, we have to assist the investigation authorities to cover the all areas, because we have seen in multiple cases in many of the cases CBI has observed that because the media has created a hurdle for tramping the witnesses. Because we have seen on the many of the scene of occurrences also, the many accusers left the various clues on the spot. But when the human interference come, the many witness and the major evidences are tempered, because as a human being come in interference, that the small issues which we can observe as a being the investigation authorities, that demolish. So what is my essential factor? Being a victim or informant, we need to assist the investigation authorities to seize, to cover all the areas where the offence has been committed. Now we need to inform what's essential factor, which I will like to say. As a being informant or as a being victim, we have seen what was the way of entry of the particular accused and what was the way to exit. because in many cases the courts observe that the way of entrance and way of exit shows the what is the conduct, and which shows the modus of operandi which helps the court to determine to the gravity of offence. So as a being informant, it is duty upon us to cover all the factors. So what will the next stage when we spot panchanamas are done, when the statements of witnesses are done? So as being the witness, as a being complainant, we need to assist the investigation authorities by helping them to providing the name of witnesses who was standing on the particular place. So whenever any IO calls you, we have to cooperate them during the investigation and thereafter. So as we have seen in many cases, as a being a common man, we are also not aware that sometimes police may say, so no boss, you have come late, or your statement may be unreliable, or your statement is not corroborating or not disclosing the cognizable offence. So you may approach to the concerned police station. Sometimes police may take the view that this particular offence or falls under the category, or you may appropriate the other forum. So under that category, what we should? When we did not agreed upon the statement made by the IO, we have to first approach to the superior authority, which we call DSP, or the superintendent of police. But before that, we have to write one complaint. Whatever we have alleged to the concerned IO, we have to allege the same incident to the superior authority. In there and after also, if superior authority does not satisfy with that, and if they refuse it to register the FIR or complain there and after, so what is our next step? So we need to file the application under 175(3) of BNSS to concerned magistrate court for seeking direction and for in the form of registration of FIR or for the to make the investigation in the particular alleged offence. So as a being litigant, we need to keep in mind what will the essentiality, relevancy, reliability and role of complainant in that. Now I am coming on to important factors which we have seen how delay can be affected. For that purpose, I am going to explain one of the incidents which I have seen during the course of trial. I will explain in the short. In one of the POXO cases, the girl was indulged around the age of 16. She was having a love and affair with one boy, and boy is having one friend. Both are the resident and residing nearby the victim, where the victim was residing. What's happened? The one boy, a boy who has indulged with the love and affair with the girl, and they were having the sexual intercourse in between. Thereafter, the person B, who was the friend of Mr. A, he threatens that girl that I come to know that Mr. A has committed the so and so sexual intercourse with you, and if you permits me to do sexual intercourse, I will not disclose this fact to your parents. This was an incident reported by the victim, and thereafter the FIR was lodged. In that FIR, the girl says that Mr. B has also committed the sexual intercourse by threatening her by stating that if you did not permit me to do particular things, then I will disclose these things in society, your name will be demolished, and in that form he has raped me. So what happened here and after? The victim lodged the first FIR against Mr. A on June 2024, and thereafter she did not narrate anything, the incident what happened with Mr. B. After 6 months, she lodged one more FIR against Mr. B by stating the whole incident. Now in this scenario, we will come to know what mistake has done by the victim itself by lodging the FIR. First mistake she has done, that she has never disclosed the incident what happened with B during the when she has lodged the FIR to the A, and after lodging FIR against A, she has deliberately lodged the FIR against B. And what mistake she has done, the timing of incident she has mentioned in the FIR, it was not matching with the what it has been alleged in FIR A. So what I mean to say, whenever you want to report any particular offence, it should not be in double format. Whatever you will double, so subsequent registration of FIR, whether is permissible or not. We have seen in many cases the subsequent registration of FIR is not permissible on the same facts and safe cause of action. So whenever happens anything wrong with you, you have to record all the incidents and you have to narrate to the concerned IO. So whenever the subsequent registration of FIR is not permissible. So in Rajpal Singh versus CBI in 2015, court says on the same facts, on the same cause of action, it is not permissible to register the FIR on second occasion. Now I am going to cover the one of these crucial factor, non-registration of FIR. In many of the cases we have seen that, and even in India the criminal report says that in many of incidents, even after the commission of offence has not been registered with the various states. This is in a very crucial area which I am going to deliver. So we need to understand, if anything is happened wrongs to you, we should not bother, we should come forward, because of your single voice, it may be it's happened that people will come across the things that people may be aware that some certain things have been happened in my society, and that maybe covers the not only the whole area, but it will help to make the further development in litigation. So I will give one example for this purpose. There was one incident where Mr. X, he was in the office and he called Mr. B for that purpose, for the making the repairs in his house, and dispute was arise there and after because the question of the payment terms comes, and whenever that question of payment terms come, the dispute was extended in such a way it was reflected between the assault of the two groups. But Mr. X did not give any complaint to concerned police station, and Mr. B along with their associate, they have assaulted Mr. X. By keeping things in mind, Mr. X there and after with the group of some people assaulted Mr. B. Now the question will comes, when Mr. B has lodged the FIR, police is going to ask you why you have not registered the FIR. So we need to keep in mind, the non-registration of FIR or non-registration of complaint, it's going to hamper your whole substance. So now the accuser has taken the plea that the version of complainant is not acceptable because he has suppressed the material fact before the court. He has assaulted me prior to the incident, and therefore because of that the things has been happened. So, but whenever if it does not disclose the particular fact to the investigation authorities, it is going to vitiate the whole defense. This is a crucial area where we have seen before the pre-trial stage, what is the role. So during the trial stage, what we need to keep in mind. So what is the role of litigation? What is the role of litigant in particular format? So during the trial, because as we have seen, we have cooperated during the phase of the investigation. Now, as we have seen that during the trial phases, in many of the cases, the litigants appear through the advocate to assist the prosecution. So in that category, the role of litigants will play important role. In many of cases, in even the Supreme Court has given direction in POXO cases that the complainant and the victim should be heard when the question of bail comes before the court. So as a being complainant, we have a right to say. So as a being complainant, we can make the intervention application, we can oppose the bail, we can assist the public prosecutor to make out the whole case before the court. Sometimes it's happened that the accused may take the wrong advantage, accused may taken that the various wrong defense. In that cases, we can assist the state for the purpose of cancellation of bail also. Now, whenever the question of a trials comes, the people shivers. They says that I need to stand before the witness, I need to stand as a witness before the court. So what will be my role? So as being we have said that your case is not proved, your case is not proved because whatever you have give the deposition or statement before the court, that has to be proved before the court. Because in many of cases we have seen the what statement they have given before the police station are turned hostile or they contradict me itself with the things. So as a duty bound upon us we have to prove the facts before the court what we have alleged in the complaint or FIR. So as a being the part of trial, as I said, कि the victim or witness stands as on driver's seat. So we have to lead the evidence. Prosecution has to lead the evidence. But for that purpose, the victim and the witnesses has to lead the evidence. They have to assist the prosecution by corroborating various evidences. So these evidences court will appreciate when the full form of corroboration and corroboration of evidence and facts comes before the court. So this is a part of the appreciation of evidence which court will determine at that stage of argument and that stage of final conclusion of trial. But these facts are very essential. So what is the duty as a being the litigant in particular form during the trial? As a trial, when court summons you, you have to appear before the court. Not we have to appear, but as a being person, we have to describe, we have to give the deposition before the court what we have narrated in the statement. So only narrating of the statement can lead that I have done my part. The answer is no. Because why it's no? Because in many of cases we have seen that TI parades police conducts for the identification of accused. So as a being witness or being the victim or being an informant, as we have seen, if the accused are unknown to us, the test identification parade with the presence of various magistrates or with the presence of Tahsildars police conducts in the jail authorities. So the identification of accused will be the very essential factor. Why it is an essential factor? As we have seen, in many of cases, delay in conduct of the TI period also going to hamper you. So we need to assist the prosecution in that case that we have to identify the accused who is standing, who is sitting in the accused box. Why it will be the essential? Because see, as we have identified in our statements, that identification has to be done during the trial when you are standing in witness box. So as we have seen in many cases, how the IO sees the various objects, material which are in incriminating nature. So we have seen that multiple clothes they seize, multiple video panchanamas they records. So we have to give the deposition in that form also. So now whenever the question of identification of clothes appears, we have to identify what clothes the accused was wearing, what object he had used, what weapons they have used. So all this with the essential factor which we have to be keep in our mind. So we have discussed in short right now what will be the role of being litigant during the phase of pre-trial stage and during the trial stage and through the investigation. We need to be keep in mind. I will give a vote of thanks to Hammurabi Tablet for providing me good opportunity to express my view upon this subject, and thank you so much.
Suresh, thank you very much. I think this was a lecture more for the benefit of the common man rather than the advocates, and that is a very good thing which you have done, because people are very much confused, because the moment you go to police station, just by going there people forget 75%. So they just don't know what to say. So it is a nice overview. You have nicely given a direction to people as to what they should do pre-trial, post-trial. So thank you very much.
Thank you.
And a small token from Hammurabi to you.
Thank you so much.